is Abigail Lowe. I will be directing Kyle Kuzak, crossing Professor Blake Van Owen, and presenting the closing argument for the prosecution.
My name is Lindsay Harriman, and today I will be conducting the opening statement for the prosecution, the direct examination of Detective Jordan Markowitz, and the cross-examination of Taylor Perkins.
My name is Caitlin Duffy. I will be conducting the direct of Alex Cifuentes and the cross of Avery Becker. Your Honor, at this time, may our witnesses introduce themselves?
Please.
My name is Lila Bednar, and I will be portraying Alex Cifuentes.
My name is Robin Kite, and I will be portraying Jordan Markowitz.
My name is Sasha Latak, and I will be portraying Kyle Kuzak.
Okay, and for the defense, enter your appearance, please.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Paige Miller. I will be doing the direct examination of Avery Becker, the cross of Detective Jordan Markowitz, and conducting the closing argument.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Kenzie Firkus, and I will be conducting the direct examination of Taylor Perkins as well as the cross-examination of Alex Cifuentes.
Evening, Your Honor. Today I will be conducting the cross-examination for Kyle Kuzak, as well as the direct examination for Professor Blake Van Owen, as well as performing the opening statement on behalf of the defense. Your Honor, permission for my witnesses to introduce themselves?
Please.
Good afternoon, Your Honor. My name is Sam Schwecke, and I'll be portraying Avery Becker.
My name is Anna Bensley, and I will be portraying Taylor Perkins.
My name is Annalise Schwecke, and I will be portraying Blake Van Owen.
Okay, thank you. Do we have the trial roster? Is there a written trial roster?
This is Dawn Rogers, the courtroom monitor. Were the teams able to upload trial rosters, or are they going to use their introductions as a trial roster?
Your Honor, I have sent a link to the prosecution's trial roster in the chat.
Yep. Okay, I see that.
And could the scoring panelists please introduce themselves?
Hold it.
Dawn, did you say the scoring panelists?
Yes, please, so we can.
The scoring panelists, please.
All right, my name is Emily Valdez.
My name is Michelle Cohen.
I'm Susan Brower.
Okay, good afternoon. All right, before we begin the trial, let me just handle a few housekeeping matters. First, I want to inform the teams and gallery members that the Colorado Bar Association may be taking photographs of the competition during the round, and that team participation in the state tournament grants automatic permission in the use of these photos by the Colorado Bar Association. Let me also ask anyone in the gallery who's connected with the teams, if there are any people in the gallery who are not connected with the teams at this time. All right, thank you. I want to remind the teams that there are no recesses allowed with the exception of those granted for health emergencies. And let me ask the scoring panelists if any of you have any reason to be biased in judging either team.
No, Your Honor.
This is Susan Brower. No, Your Honor, but can I just say that I need a minute to get the names into the scoring sheets before we get started?
Go ahead.
All right, I have to figure out how to do it. Sorry. I see the link.
defense roster says it needs permission to be accessed.
I don't know how to get back to it either.
Apologies, I'll be sending a link that you can access now.
Okay, and it is
Thanks, Anna.
it's in the chat box. And it's telling me I need access to Google Docs.
Okay, may I proceed or are we still loading?
Well, I apologize. I've got the roster, but I don't know how to save the information so I can put it in my sheet. So I apologize. I do need another minute.
Susan, are you able to look at the names and determine whether or not you have a conflict with any of the participants?
I listened to the, I'm going to print it. I listened to the introductions and I have no conflicts.
Okay. And Ms. Valdez, do you have any conflicts with any of the participants?
No, I do not.
Ms. Cohen, do you have any conflicts with any of the participants?
I do not.
And are there any participants who have any conflicts with the scoring panelists that haven't been raised by the scoring panelists? Okay, hearing nothing, I do not believe we have any conflicts. Just let me confirm with the other courtrooms that they do not.
Okay.
And Your Honor, I am being told that there are no conflicts in the other courtrooms. So when our courtroom is ready, we can get started.
I just need one more minute, please. I'm really close to having everything done. Just trying to print the second trial roster.
All right, let me just go over a couple more things, housekeeping matters, before we actually begin the opening statements. I want to remind the teams and coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. I want to remind the teams that their compliance with the time requirements will be considered in scoring individual performances. Also, I want to advise the teams that I do not allow recross examination of witnesses. And when we're ready, I'm ready to swear in the team members, the scoring panelists, and the witnesses.
This is Susan Brower, Your Honor, I'm ready.
Okay. Can I have the team members please raise your right hands, and if you agree with this oath, say I do. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition? All right, responses in the affirmative. Let me have the witnesses raise their right hands. Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements and that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? All right, responses in the affirmative. And then let me have the scoring panelists please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes.
All right, responses in the affirmative. Thank you. All right, are we ready to proceed?
Your Honor, may the prosecution speak of preliminary matters?
You may.
Thank you. Permission for the exhibits to be constructively published to the jury only after their admission.
Granted.
Permission for time to be paused should any technical difficulties arise.
It'll be granted.
And permission for stipulated facts to be constructively read into evidence.
Granted.
Permission for remaining time to be used for rebuttal and closing statements.
It's granted.
And the prosecution also asks that the same privileges be granted to the defense.
Same privileges will be granted to the defense. Thank you.
No further preliminary matters, Your Honor. Thank you.
Right, does the defense have any preliminary matters to raise at this time?
No further preliminary matters, Your Honor.
Okay. Then are we ready for opening statements?
Taking that one step too far can escalate a situation to a point of broken ties with mentors and friends. Taking another step too far can escalate a situation to a point of disaster and tragedy. Friday, March 6, 2020 began normally enough. We could feel springtime approaching as we looked forward to the time we would spend relaxing and recovering over the weekend. Mackenzie Brackman started his weekend early. Having that Friday off, Mr. Brackman had spent the morning quietly in his home. Mr. Brackman had dedicated his life to the law. Not only was Mackenzie Brackman a successful criminal defense lawyer, he also coached a team of young students in Colorado High School's mock trial club. Mr. Brackman couldn't have anticipated that his life was about to be stolen. At approximately 1:05 p.m., an intruder walks past Mackenzie Brackman's security cameras and into his backyard. The intruder steps into Mr. Brackman's home through the back door. Inside, the intruder startles Mackenzie Brackman. Scared and confused by the intruder in his home, Mackenzie Brackman grabs a knife from his kitchen in hopes of fending off the intruder. The intruder is relentless. Ms. Brackman loses the knife to the intruder. Now in possession of the knife, the intruder becomes a killer, stabbing Mackenzie Brackman in his shoulder. The killer immediately escapes, fleeing Mr. Brackman's residence. Mr. Brackman, in pain and bearing a fatal stab wound, makes his way to his front door. There, he pulls the knife out of his shoulder and he begins to bleed. Mr. Brackman, a man who had dedicated his life to the law, took his last breath in the doorway of his own home. He bled to death. He did not get to say goodbye to his students or his family. Today, Mr. Brackman's killer sits before you. The police concluded that Avery Becker, a student on the Colorado High School mock trial team, broke into Mackenzie Brackman's home. The evidence shows that in the process of the burglary, Becker was startled by Mackenzie Brackman, killing him as a result. Avery Becker is on trial for the burglary and murder I just described. Becker is charged with burglary and felony murder. In the previous months, the defendant had battled with Coach Brackman about his lackadaisical attitude towards mock trial. Unrelenting in nature, the defendant continued to disagree with his coach. You will learn that after facing criticism about his work ethic from Mr. Brackman, the defendant retaliated against him, taking his hatred for his coach a step too far in vandalizing his vehicle and permanent marker. Mr. Brackman decided to remove the defendant from his mock trial team. This angered the defendant. The defendant took his hatred for Mackenzie Brackman a step even further. The evidence shows that the defendant broke into his coach's home with the intent to vandalize it like he had vandalized the vehicle. After being caught off guard by Mr. Brackman, the defendant took a leap too far. In today's trial, you will hear from a homicide detective of 7 years, Detective Jordan Markowitz, and a crime scene investigator of 19 years, Kyle Kuzak. Detective Markowitz confirmed the defendant's location at the date and time of the crime by obtaining detailed records of incoming calls to the defendant's phone and drawing a map that depicts the progression of the defendant's location. Kyle Kuzak analyzed the evidence matching the events of Mackenzie Brackman's murder. Colorado High School student and mock trial member Alex Cifuentes observed the defendant's disgruntled association with Mackenzie Brackman, his coach. Ms. Cifuentes witnessed each time the defendant took a step too far in his retaliations against Mr. Brackman's criticisms. We, the prosecution, have the burden of proof. This means that after considering all of the evidence presented throughout this trial, you, the jury, will decide whether we have proved the defendant's guilt beyond any reasonable doubt. We will show you that the defendant committed first-degree murder and second-degree burglary. When making your decision, we ask you to consider a distinction between mere claims and hard evidence. After listening to the evidence and witnesses presented in this case, we, the prosecution, will ask you to prevent the defendant from taking another step too far. The hard evidence in this case, gathered in this investigation, proves the defendant guilty of his crimes. Please convict the defendant of murder in the first degree and burglary in the second degree.
Thank you. The defense wish to make an opening statement?
Yes, Your Honor. A chain is only as strong as its weakest link. Avery Becker, the weakest link, was looked at before the evidence. Today, ladies and gentlemen, you will find that the detective's case is made up entirely of weak links. You will learn that evidence police gathered was either not used or simply circumstantial. In fact, some of the evidence they used was lost. That is only the first weak link. The second, the witnesses. Two, who are investigators. The same investigators that rushed this entire investigation. And the weakest link of all, the defendant himself, Avery Becker, a young man with a bright future. The case we will present to you today is that of a young man who should be dreaming of all that lies ahead, but instead he's being unfairly accused of murder. Avery Becker is only guilty of one thing, losing his phone. The prosecution's case rests on Avery's past mistakes leading him to murder, but many know that people don't always make the best decisions. That does not mean that all people who have ever made mistakes are murderers. Avery Becker is just a boy who made a simple mistake and is now being faced with murder accusations for a crime he did not commit. Avery Becker wanted to end his senior year on a good note, on good terms with the team he had been part of his entirety of high school. Avery Becker made a mistake, and investigators used that as a leverage to find him guilty of murder. Avery Becker, the weakest final link, was looked at before any other suspect, some who even might have more motive than himself. Today, you will be hearing from 3 witnesses. Expert witness, Professor Blake Van Owen, who is a professor, private investigator, and an expert witness in police practices. She will be able to give you an expert explanation for disproving evidence claiming to point to Becker, but simply is just speculation, as well as providing a secondary suspect with a strong motive, perhaps even stronger than the defendant himself, that the prosecution refused to look into out of pure negligence. You will hear from witness Taylor Perkins, Avery Becker's close friend. Teenagers tell their best friends everything. Taylor Perkins will testify under oath that she was with Avery Becker on the day the victim was killed and will be able to tell us where they were on the day of this crime that she knows Avery did not commit. Not only because she was with him the whole day, but because she knows her best friend would never commit such an atrocity over a petty feud. And finally, the defendant himself, Avery Becker, who will take the stand to prove to the jury that he's indeed innocent of this crime and that he's simply a young man who would never do anything to jeopardize his entire future. Avery Becker has his whole life ahead of him, a life he wouldn't simply throw away from one club, from one small part of his life. Avery Becker wanted that spot back on the mock trial team. So why would he do something to risk his last chance on that team? Avery Becker simply didn't get along with everyone, and now that could cost him a lot more than it should. The detectives in this case took the first opportunity they saw to find Avery Becker as a suspect and ran with it, without the thought of accepting the rest of the evidence that blatantly shows Avery did not commit this crime. They looked at Avery Becker before looking at the evidence. Avery Becker's only crime was that of just losing his phone. Today, we ask you, the jury, to simply listen to what Mr. Becker has to say and find this man not guilty of committing these crimes. We ask you to look beyond his mistakes, as you would ask anyone to do for yourself, and find him not guilty of this heinous crime.
Thank you. Does the prosecution wish to call your first witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand. Good afternoon, Ms. Cifuentes. Please state your name and spell your last name for the record.
My name is Alex Cifuentes, Sifuentes.
How would you describe your association with the defendant?
Avery and I were best friends, and we were also teammates together in mock trial.
Who was Mr. Brackman?
Mr. Brackman was our amazingly talented mock trial coach, and he was also a local defense attorney in addition to that.
And what did you observe about Avery's and Coach Brackman's interactions in mock trial?
Unfortunately, Avery and Coach Brackman didn't really get along at all. They were constantly arguing with each other and butting heads, just not really agreeing on how mock trial should be run.
What qualities and habits did Coach Brackman stress in mock trial?
Objection, Your Honor. Relevance.
Overruled.
I apologize, Your Honor. What qualities or habits did Coach Brackman stress in mock trial?
Coach Brackman always stressed the importance of proper preparation for tournaments and practices, coming to practice on time, overall just taking mock trial very seriously.
And what was Avery's work ethic like?
Well, Avery's work ethic was not really up to that standard set by Mr. Brackman. He was always coming to practice late, improvising his way through tournaments, just not taking it seriously.
Objection, Your Honor. Lack of personal knowledge to the last statement.
Response.
Your Honor, the witness has testified to being in mock trial. It's not unfair that the witness could have observed or saw anything involving Avery's work ethic.
Any reply?
Your Honor, I'm specifically referencing the part where Ms. Cifuentes testified that Avery did not take mock trial as seriously. There's no way for the witness to understand how seriously Mr. Becker took his role in mock trial.
Okay. I'll sustain the objection on regarding that specific question.
Movement to strike, Your Honor.
Granted. Go ahead.
What competitions did Colorado High School mock trial team participate in last year?
Last year, we had participated in the regional tournament.
How did Avery react to Brackman's feedback after regionals?
After regionals, Avery was very upset with how Coach Brackman was criticizing
Objection, Your Honor. Lack of personal knowledge.
Response.
Your Honor, may I go back to build the foundation for personal knowledge?
You may.
All right, Ms. Cifuentes. Were you there at the practice when feedback was being given?
Yes, I was.
And what did you observe, or excuse me, how did Avery react to Brackman's feedback after regionals?
From what I saw, Avery looked very upset and was very angry with how Coach Brackman was criticizing him.
And what did how did the conversation end?
The conversation between Avery and Coach Brackman ended pretty badly, with Avery grabbing a marker and leaving the room, looking pretty angry.
Did Avery Becker get kicked off the team after this incident?
Yes, Avery was kicked off the team as a result of what happened.
And did Avery contact you after they got kicked off the team?
Yes, Avery sent me text messages asking if I would talk to Coach Brackman about
Judge,
getting him
Your
back.
Honor, hearsay.
Response?
Your Honor, this is being used to lay foundation for evidence that will be entered that is not hearsay.
Well, this is a statement made by the defendant. Is that your question?
Yes, that was what I was objecting to.
Yeah, okay, overruled. Go ahead.
Would you like me to repeat the question?
Yes, please.
Did Avery contact you after they got kicked off the team?
Yes.
Your Honor, permission for the witness to view Exhibit 14.
You may.
Let the record reflect that my co-counsel is showing what has previously been marked as Exhibit 14. Ms. Cifuentes, do you recognize Exhibit 14?
Yes, these are screenshots of the text messages that I was just talking about before.
What is Exhibit 14?
These are the messages that were exchanged between Avery and I.
Is Exhibit 14 a complete and accurate copy of the text messages exchanged?
Yes.
Your Honor, I move to admit Exhibit 14 into evidence.
Any objection?
Yes, Your Honor, Rule 1002, requirement of the original.
You want to lay a foundation as to authenticity?
Your Honor, may I please respond?
Yeah.
Your Honor, excuse me. Just one moment. This exhibit does meet the requirement of original because according to 1001D, excuse me, 1001, yes, D. It says that for electronically stored information originally means any printout or other output readable by sight if accurately reflects the information. Therefore, this exhibit here meets the requirements of the definition of an original.
Permission to reply, Your Honor.
You may reply. Go ahead.
Your Honor, I don't believe that opposing counsel has laid proper foundation that this accurately reflects the text messages sent by Avery Becker. Avery Becker will testify on his direct examination that he did not send these text messages.
All right, well, I'm going to admit it, and that testimony can go to weight, but not admissibility. So it is admitted.
All right. What did Avery ask you over text, Ms. Cifuentes?
Over text, Avery asked me, is there, sorry, the screen is scrolling. Avery asked me, is there any way you'd be willing to talk to Coach Brackman about having me back in reference to getting back onto the team?
And how did you respond to this?
I said that I guess I could try, but after the whole incident with the car, it would be pretty hard to change his mind.
How did Avery respond to your text?
Avery responded with, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
How did you respond to this, Ms. Cifuentes?
I asked, what are you going to do to his house? And Avery responds to that with, I'm going to wait until he's at work, then break in and trash it.
Why were you willing to let talk to Brackman on letting Avery back on the team?
Well, Avery having to leave the team put us in a pretty bad position. We were probably going to have to forfeit going to our state competition. So I really wanted us, the whole team, to be able to participate in that.
Let the record reflect that my co-counsel has stopped sharing Exhibit 14. Did anyone reach out to you in regards to these text messages?
Yes, I was contacted by Detective Markowitz.
Why did you feel the need to come forward about these messages?
Well, of course, the last thing I would ever want to do is get Avery in trouble. I mean, he was my best friend, but after getting these text messages, it was pretty concerning, and I felt like I had to come forward.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Cifuentes. Let's begin. You claim to be good friends with Avery Becker, correct?
I was good friends with Avery Becker, yes.
Although you and Avery only spent time together within mock trial and related events, correct?
Well, we did spend a lot of time together through mock trial. It's a pretty big time commitment, so yes.
You also felt that Avery had no real talent when it came to the mock trial team?
Well, I wouldn't really say that. Avery was certainly very talented at improvising. I mean, that is the reason why he won those awards at the regional competition.
It upset you that Avery got such large roles on the team?
It was certainly a little bit upsetting just because of the fact that Avery wasn't quite working as hard as some other people on the team were.
The fact that Avery earned multiple awards in mock trial despite his lack of work was very upsetting to you?
Somewhat, just considering the work ethic involved.
So that is a yes, it was upsetting to you when Avery got those awards?
To a limited extent, yeah.
You felt that the mock trial team was better off without Avery once he was removed?
Well, I wouldn't say that. We would have had to forfeit going to the state competition because the mock trial rules state that you can't just substitute somebody in at the last minute. And everyone on the team was pretty upset with that.
However, your team didn't end up going to state last year, is that correct?
No, because of all that, what happened with COVID, we didn't end up going anyway.
To continue about your relationship with Avery, you were looking forward to getting larger roles with Avery off of the team, also correct?
Objection asked and answered.
Response?
Your Honor, I previously asked about whether or not it was upsetting to the witness when Avery had such large roles on the team, as well as if it upset them when they won awards on the team. However, I have not asked if they were looking forward to getting larger roles with Avery off of the team.
Okay, overruled.
Permission to restate my question.
You may.
Ms. Fuentes, you were looking forward to getting larger roles with Avery off of the team?
Sure I was, yeah.
Let's discuss Exhibit 14. Detective Markowitz calls you in for an interview regarding information on your phone, correct?
Yes.
However, you didn't bring your phone with you to the interview.
No, my phone was getting super old and couldn't really hold a charge, so as I was charging it, it just completely slipped my mind.
So that is a yes, you didn't bring your phone with you to the interview.
I completely forgot to bring it to the interview, yeah.
You didn't realize you had forgotten your phone at any point on the way to the interview?
No, I mean, I'd never been interviewed by a detective before, so I was feeling pretty nervous in addition.
Detective Markowitz never asked you to bring in your phone at a later time.
No, but I did offer to, but she said it would be okay if I provided screenshots of the text messages.
To go off of that, Detective Markowitz had you email him had you email her screenshots of the alleged messages, correct?
Yeah, she said it was okay to do that.
You traded in your phone, even knowing it contained this evidence.
Well, I traded in my phone after I had given the evidence that I had, that being the text messages, to the police.
But that is a yes, you are aware that your phone contained evidence when you traded it in?
I was aware my phone had evidence, but I gave the evidence that was in it to the police before I traded in my phone.
You no longer have direct access to those text messages?
No, I don't. I do have the screenshots, though.
You don't have any idea where the phone you originally received these messages on is now?
No, I traded it in.
To confirm, you claim to have received alleged text messages from Avery Becker with threats to break into Coach Brackman's home, correct?
Yes, I did receive those messages.
Despite receiving these messages, you didn't find it necessary to warn Mr. Brackman prior to his death?
Well, Avery notoriously does have pretty heightened emotions sometimes, and of course I'd never want to believe that Avery would actually go and do something like this.
A yes or no answer will suffice, Ms. Fuentes.
I didn't, but as I said before...
Did you ever contact the authorities with this information?
I gave the information that was on my phone to the police when they asked for it.
Prior to Mr. Brackman's death, you never warned the police that Avery had threatened to break into his home?
No, I mean, I didn't want to believe Avery would seriously go and do something like this.
in fact, even after Mr. Brackman was killed, you didn't contact the police. Detective Markowitz contacted you.
Yes, that is true.
Let's talk about March 5th, 2020. That's the night before Mr. Brackman was killed. You saw Avery Becker at the Fry Shack that night, correct?
Yes, the whole mock trial team was there.
And at some point, you were in possession of Avery Becker's phone?
Yeah, Avery and I were having this great conversation about moving forward from mock trial, and that's when I briefly had access to her phone.
So that is a yes, you were in possession of Avery Becker's phone at some point that night?
Yes.
Let's move on. You are aware that Mr. Brackman had previously represented a parent of a student at your school?
Vaguely, yeah.
You also attended school with Blair Rollins?
I did, but I didn't know Blair at all, really.
Ms. Cifuentes, I did not ask about your relationship with Blair Rollins, only if you attended school with him. So that's a yes, you attended school with him?
Yes.
You haven't seen Blair Rollins since Mr. Brackman was killed?
Like I said before, I don't know Blair. I don't know anything about Blair. So no, I don't know.
However, you attended school with Blair, so you did see him on a regular basis in hallways and such.
Well, sure, I saw him in the hallways and everything, but certainly not well enough to say hello or anything.
So you have not seen Blair Rollins in those hallways and such since Mr. Brackman was killed, correct?
No.
Thank you, Your Honor. No further questions.
Thank you. Any rebuttal?
Yes, Your Honor. I have a reading.
Direct. Go ahead.
Yes. Who convinced you to join mock trial?
Avery did when I was a freshman.
Objection, Your Honor. Relevance.
What's the relevance?
Your Honor, my witness was being questioned on the relationship with the defendant. They obviously had to be getting along if Avery wanted Miss Cifuentes on the mock trial team.
Okay, you want to reply?
Your Honor, these events that opposing counsel is speaking of happened in Ms. Cifuentes' freshman year of high school. Ms. Cifuentes is now a senior and relationships change.
All right. Overruled. You can ask the question.
Who convinced you to join mock trial?
Avery did.
And can you elaborate more on your relationship with Blair Rollins?
As I said before, I barely knew Blair. I knew him in the sense that he did go to our school, but other than that, I didn't know anything about him or who he was really, so.
No further questions, Your Honor.
Okay, thank you. May this witness be excused? No objection? Okay, thank you very much. People wish to call their next witness?
Yes, Your Honor, the prosecution calls Detective Jordan Markowitz to the stand. Good afternoon. Please state your name and spell your last for the record.
Good afternoon. My name is Jordan Markowitz, and that's Markowitz.
Let's start by having you tell the jury a bit more about yourself, Detective Markowitz. What do you do for a living?
I'm a detective. I work with the Denver Police Department, and I've been a detective for 7 years now, although I started my career with the DPD about 13 years ago.
Why are you testifying today?
I'm testifying today because on March 6th of last year, I was assigned to investigate the death of Mackenzie Brackman, who was a criminal defense attorney as well as the coach of the Colorado High School mock trial team.
What specialized training have you received?
I have specialized training with cell phones. I'm certified by the American Academy of Law Enforcement in cell phone technology and forensic data recovery. And in order for me to receive that certification, I had to take a training course on it as well as pass a certification test.
How often do you use that training?
I mean, in my job as a detective, I use that training constantly.
Your Honor, at this time, I move to tender Detective Jordan Markowitz is an expert in crime scene investigation and forensic data recovery on the grounds of her experience and training.
Any objection?
No objection, Your Honor.
Okay, then this witness will be accepted as an expert in those areas. Go ahead.
Let's talk about the defendant. How did you learn of the defendant?
I learned about the defendant, Avery Becker, after I learned about the mock trial team and Mr. Brackman's relationship with the mock trial team. I learned about this relationship with the mock trial team through, first of all, Mr. Brackman was wearing a mock trial shirt when we found him. And second of all, after I downloaded the contents of his phone, there were a whole lot of messages discussing mock trial. So I knew that it would be a good starting spot to investigate any relationships that Mr. Brackman had in mock trial. So I called Colorado High School, got the phone numbers of the students, and that's when I found out about the defendant, Avery Becker, after I called a student named Alex Cifuentes.
What interviews did you conduct throughout this investigation?
Well, after I spoke to Ms. Cifuentes on the phone, I called her in for an interview. And the reason that I called her in was because over the phone, she mentioned some highly concerning text messages that she received from Avery Becker, which is why I invited her in. And from there, I learned that Avery Becker had vandalized Mr. Brackman's car, and then Avery Becker got kicked off of the mock trial team. And then that's when I saw those text messages, which I believe we saw earlier today.
Your Honor, permission for my co-counsel to share her screen with Exhibit 14, which has previously been admitted into evidence.
Granted. Go ahead.
What did you do after learning about these texts?
Well, naturally, I reached out to Avery Becker, and we arranged to have him come in so I could conduct a full interview with him. But unfortunately, just before the scheduled time that we had for the interview, I was called by an attorney hired by Avery Becker's parents and told that I would not be allowed to speak to him.
Detective Markowitz, will you please read the defendant's last two messages aloud for us?
Yes. The defendant says, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait until he's at work, then break in and trash it.
Let the record reflect that my co-counsel has stopped sharing her screen with Exhibit 14. Let's talk about what you observed on the scene of Mr. Brackman's murder. How did Mr. Brackman look upon your arrival at the scene?
Well, Mr. Brackman was lying face down in the front door area of his residence. He had a knife wound in his upper left shoulder and back area. There was blood pooling, and there was also a knife nearby his body that had blood on it.
What did you observe about Mr. Brackman's kitchen?
Well, the first thing that I noticed when I was making my roundabout and I looked into Mr. Brackman's kitchen, the first thing I noticed was that it was in general disarray. But there were two really important things I'd like to mention here, which is one, that there was a knife block that had one large knife missing, and two, there was also a drawer that was ajar and had a large variety of different kinds of knives in it.
What did you see outside of Mr. Brackman's home?
I noticed almost immediately that Mr. Brackman had a Ring doorbell, which is like a camera in place of a doorbell. And so after realizing that Ring security system, I went around to check if he had any other camera set up, which he did. He also had one set up facing the back gate and one set up facing the back door.
How did you obtain access to this security footage?
I downloaded the contents of Mr. Brackman's phone, as I mentioned earlier, and that included the Ring security, his Ring account. And so from there, I could access the footage.
Detective, are you familiar with Exhibits 10, 11, 12, and 13?
I am. Those are the videos that I was just talking about from March 6th that show an intruder breaking into Mr. Brackman's house.
To your knowledge, have copies of Exhibits 10, 11, 12, and 13 been provided to opposing counsel?
They have.
Are these exhibits accurate copies of the Ring security footage you obtained from the crime scene?
Yes, they are.
Your Honor, at this time, I move to admit Exhibits 10, 11, 12, and 13 into evidence.
Any objection?
No objection, Your Honor.
Okay. These are exhibits, would you say 10, 11, 12, and 13?
That's correct.
All right. They're admitted at this time.
Your Honor, permission to share my screen with these exhibits.
You may. Go ahead.
Detective Markowitz, will you please describe what is happening in the exhibits 10 through 13 as they play on your screen?
Sure. So this is the view from the Ring doorbell. We see a masked intruder wearing gloves and a hoodie coming up. They try to unlock the door, but upon realizing it's locked, we see them start to head around toward the back gate. This is the view from the back gate. And we see the intruder opening up the back gate and then proceeding to go to the back door. This is the footage of the back door and the intruder entering it after seeing that it's unlocked. And again, this is more footage from the Ring doorbell at the front door. You see the intruder sprinting away.
Let the record reflect that I have stopped sharing my screen with exhibits 10 through 13. Let's discuss the connection you made between the crime scene and the defendant. After receiving the screenshots and the defendant's refusal to be interviewed, what did you do?
Well, I got a warrant to search Avery Becker's cell phone, but again, I was contacted by Avery Becker's attorney, and I was told that Avery no longer had access to his cell phone. So after that, I was luckily able to obtain Avery Becker's phone number, and with that, I got the call detail records for March 6th.
What are call detail records?
Call detail records are essentially records of any sort of communication with a phone, so whether that be call or text. And it also, and this is the crucial part, call detail records show us which specific antenna of which cell tower the phone was connected to, which allows me, when I'm analyzing the data, to get a really good perspective of how the phone moved and where it was at a particular moment in time based on the communications.
What did the defendant's call detail records show?
The call detail records showed that, well, we can see essentially a pathway of Avery Becker being in his house and then moving towards Mr. Brackman's house and then being in Mr. Brackman's house during the time of the murder.
Detective Markowitz, please turn to Exhibit 15.
Exhibit 15?
Yes. Your Honor,
would you like me to?
Your Honor, permission for my co-counsel to share her screen?
That's fine, thank you.
Let the record reflect that my co-counsel is sharing her screen with Exhibit 15. Detective Markowitz, do you recognize Exhibit 15?
I do. This is a diagram that I made that shows the movement of Avery's cell phone, and I used the data that I gathered from the call detail records to create this diagram.
Is this a fair and accurate representation of Exhibit 15?
Yes, it is.
Your Honor, I move to admit Exhibit 15 into evidence.
Any objection?
No objection, Your Honor.
15 will be admitted, but next time, please admit it before you show it to the jury.
I apologize, Your Honor. I thought we had addressed that in preliminary matters. May I continue?
You may.
In summary, what do the call detail records indicate?
Well, the call detail records showed that between around 12:45 and 12:50 p.m., Avery Becker was at home, and then he left and drove towards Mr. Brackman's house through this sort of route that travels through these red areas of the antenna at around 12:55, and then between 1:05 and 1:17, Avery Becker was at Mr. Brackman's house.
Let the record reflect that my co-counsel has stopped sharing your screen with Exhibit 15. Let's talk about your conclusions as an investigator in this case. How have you reached your conclusions?
all of my conclusions are based on my experience working as a detective on homicides, as well as the special training that I received with cell phone technology and cell tower data.
What final conclusion did you reach as an investigator in this case?
Well, based on all of the evidence that not only myself and my team gathered, but also our crime scene reconstructionist gathered, it is clear that Avery Becker, after having this dispute with Mr. Brackman, as evidenced in those text messages, he decided to vandalize Mr. Brackman's house. But unfortunately, Mr. Brackman happened to be home. He was alerted to the intruder by his Ring security system. So he armed himself with a knife, either from that knife block or from the drawer. And then he tried to fight off the intruder, but unfortunately the intruder prevailed, stabbed Mr. Brackman in the shoulder, and then left the scene.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good evening, Detective Markowitz. Let's start with your experience. You have been a detective for 7 years, correct?
That's correct.
You claim to have specialized training with cell phones?
I do have specialized training. I'm certified by the American Academy of Law Enforcement.
This specialized training was a 3-day course, correct?
Yes, that's correct, as well as a certification test.
Let's talk about Ms. Cifuentes. Alex did not provide her phone on the day of your interview, correct?
No, Alex did not bring her phone with her, and I just had her send in the screenshots of the text messages.
You didn't bother ask Cifuentes to reschedule or have her bring her phone in on a separate date?
Objection.
Ms. Cifuentes.
Your Honor, compound question.
Your response?
May I rephrase the question?
Rephrase, that's fine.
You didn't ask Cifuentes to reschedule, correct?
No, I did not. I interviewed Ms. Cifuentes that day, then and there.
You didn't ask her to bring her phone in on a separate date?
Ms. Cifuentes did offer to bring her phone in, but there was no need since we could just use the screenshots.
Cifuentes emailed the screenshots the day after the interview, correct?
Yes, that's correct.
So a whole day had passed before you got the evidence you requested?
No, I don't believe I've made a statement as to it being a whole day. It was in the morning that she sent the screenshots, and the interview had been the previous evening. It was a reasonable amount of time.
You have training with software that allows you to download the contents of a cell phone.
I do.
And you didn't bother to use that to download the messages off of Alex's phone directly?
Well, it's not a matter of not bothering. It's a matter of it not being necessary.
Let's talk about your investigation process. You claim good police work requires you to follow up on all possible leads?
I do.
You recognized Brackman when you found him?
Yes, I did. I recognized him to be a criminal defense attorney.
You were aware of the possibility that this murder could be the work of a previous client?
Well, yes, as a detective, you go through a whole lot of theories in your head, but ultimately it's where the evidence leads you that your case follows.
Blair Rollins' father was a client of Brackman's, correct?
I believe you're talking about Jonathan Rollins. I don't believe I've made a statement on that, but I could start now if you'd like.
Well, the fact that Blair Rollins' father was a client of Brackman's, this ties Blair to Brackman.
My team and I, we did do an investigation into Blair Rollins. You know, we investigated many different suspects, but no evidence led to anyone other than Avery Becker.
So during this investigation, you let the evidence guide you to your suspect?
Well, you go where the evidence takes you as an investigator and you follow the leads, which is what I did.
The evidence guided you straight to Avery?
Yes, it did.
In letting the evidence guide you, you didn't consider outside possibilities?
I'm not sure what you mean by outside possibilities, but if you're asking me if I don't know, if I only focused on Avery Becker, that's not the case. Like I said, my team and I investigated other suspects, but everything led to Avery Becker.
So you did look into Blair Rollins?
Yes, my team and I, including Kyle Cusack, we did do some investigation into Blair Rollins.
Blair's cell phone location was included in the call detail records you provided today, right?
No, Blair's cell phone location was not included.
Blair's cell phone was included in the call detail records?
No, Blair Rollins' cell phone was not included in the call detail records.
Your Honor, may the witness view Exhibit 15?
Yes.
Objection, Your Honor. Vague question.
She just asked if she could review an exhibit. Exhibit 15.
The line of questioning prior to this, including sharing Exhibit 15, I believe that my witness was unfortunately confused by opposing counsel's question. Ms. Miller never clarified whether or not she was referring to Exhibit 15. Counsel,
the question was, can Exhibit 15 be shown to this witness? That request is granted. Go ahead.
May I proceed?
Yes.
So in Exhibit 15, I am sorry, I actually did misspeak. That's Rollins' house in the records, not Rollins' cell phone, correct?
Yes, Blair Rollins' house, not Blair Rollins' cell phone.
Right, so Rollins was included in evidence, correct?
Yes, as I already said, my team, we did a thorough investigation, but nothing connected the case to Blair Rollins, and none of the evidence led us to Blair.
So despite Blair being included in this evidence, you didn't once mention Blair in your affidavit?
Blair is not included in the evidence. As I said, nothing led to Blair, but I do talk about Exhibit 15 and Exhibit 16, which hasn't been entered. But I talk about those in my affidavit, and so we investigated Blair, but I don't think that it would be necessary to comment on somebody who was not at all connected to our investigation as far as the evidence goes.
Thank you, Your Honor. No further questions.
Can you redirect?
Yes, Your Honor. Detective Markowitz, let's briefly discuss your investigation into Blair Rollins. Did you consider suspects other than Avery Becker during your investigation?
Yes, we did.
As an investigator in this case, to whom did the evidence lead you?
All of the evidence that we gathered led us to Avery Becker, and that includes especially the call detail records, the ring security footage, as well as those text messages.
No further questions, Your Honor.
Thank you. May this witness be excused? All right, no objection. All right, witness may be excused. All right, prosecution wish to call their next witness.
Yes, Your Honor. The prosecution calls Kyle Cusack to the stand.
Okay, go ahead.
Oh, my apologies, Your Honor.
Go ahead.
Good afternoon, Ms. Cusack. Please state your name and spell your last for the record.
My name is Kyle Cusack, K-U-Z-A-K.
What is your profession?
I am a crime scene reconstruction investigator.
What's your relation to this case?
I was a crime scene reconstruction investigator for this case.
How long have you been a crime scene reconstruction investigator?
19 years.
What do you do as a crime scene reconstruction investigator?
I investigate complex crime scenes such as home invasions, burglaries, armed robberies, homicides, things of that nature.
Where are you employed as a crime scene reconstruction investigator?
The last 3 years of my tenure have been with the city of Denver. I'm a civilian employee of the Denver Police Department.
What special licenses or certifications do you have in the field of crime scene reconstruction investigation?
I'm certified by the Colorado Bureau of Investigation.
Your Honor, at this time, I move to tender Kyle Cusack as an expert in crime scene reconstruction investigation on the grounds of experience and knowledge.
Any objection?
No objection, Your Honor.
All right, witness will be accepted. Go ahead.
Ms. Kuzak, how do you carry out crime scene reconstruction investigation?
Well, I'm guided by two key principles. First, I assume every case is going to trial, so I conduct a thorough investigation accordingly. Second, starting from day one, I document, organize, and memorialize all the evidence with a mindset of future reconstruction.
What hands-on investigation did you do in this murder case, if any?
I visited the scene of the crime.
Why did you visit the scene of the crime, Brackman's residence?
Visiting the scene of the crime allows you to have a deeper degree of understanding because you're visually observing the evidence for yourself, something you wouldn't be able to gain by just reading a report.
What evidence did you find in your investigation?
Well, there were ring security camera videos, scuff marks on the kitchen floor, a broken kitchen plate, a knife block with a missing knife slot, an open knife drawer, blood cast off, and blood droplets, as well as the knife used in the murder itself.
What were the origins of the knife used in the murder?
It either came from the knife block with a missing knife slot or the open knife drawer.
What did the broken plate and scuff marks suggest?
They indicated a struggle between the victim and the intruder. As the intruder enters Brackman's residence through the back door, Brackman is armed himself with a knife. They have a struggle, causing black scuff marks on the kitchen floor. As they continue to struggle, they move to the kitchen table and bump a kitchen plate off the table.
In your expert opinion, what occurred in this altercation between the defendant and Mr. Brackman?
Well, as the two continued to struggle, the intruder restrained Brackman in a bear hug-like fashion, then stabbed Brackman in the upper shoulder area. After this, the intruder flees the scene through the front door, as seen in the ring security camera videos. Brackman makes his way to the front door, pulls out the knife, and dies.
Have you read or been aware of any other reports of this case?
Yes, I have.
To your knowledge, are there any other interpretations of the evidence?
Yes, there is another alternate theory that thinks that Brackman was stabbed seated down at the kitchen table.
Do you agree with this interpretation?
No. First of all, Brackman would have to have been surprised by the intruder. That wasn't the case. Brackman was alerted to the intruder's presence either via ring security notifications or hearing the back door slide open. Second, the intruder would have had to have been holding the knife in a manner just about opposite the way everybody would have held a knife.
What would you have to do to come to this alternate interpretation?
To come to this alternate interpretation, one would have to be reviewing the evidence with a predetermined outcome in mind.
And lastly, how would you summarize what occurred at the Brackman's residence, March 6, 2020?
Well, this is a burglary gone bad. The intruder had knowledge of the victim's residence and whereabouts, chose a time of day that would have normally displaced Brackman outside of his house. That wasn't the case. The intruder came to the residence. Brackman armed himself with a knife. Upon being alerted to the intruder, they had a scuffle, and then Brackman was ultimately stabbed with the same knife he introduced into the encounter.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Before I begin, may I ask for a brief time check?
Time check.
Thank you. May I begin?
Yes.
Thank you. You have visited the scene of the homicide after it was processed by other members of the crime lab, correct?
Yes.
There were scuff marks found on the kitchen floor of the scene of the murder?
Yes.
You stated the scuff marks could have been the result of some sort of struggle, correct?
Yes, they were the result of some sort of struggle.
Those scuff marks could have been created before the homicide occurred?
I mean, it's a possibility, but not the most likely outcome. If you look at the ring security camera videos, you'll see that the intruder is wearing black shoes with thick soles. These shoes are the most likely that would cause scuff marks on a wooden floor.
But just to clarify, there is no definitive way to tell when those scuff marks were created?
Again, it's a possibility that they weren't created in the struggle, but it's not the most likely outcome.
Now let's move on to the Ring security app. You stated that the Ring app could have alerted Mr. Brackman to the presence of an intruder on his cell phone, correct?
Yes.
Brackman's phone was not at any point obtained for further investigation on the Ring Security app?
No, it was. Detective Markowitz processed Mr. Brackman's phone using Celebrite.
Was it known if Brackman turned off his notifications to his phone or not?
I have not previously given a statement about that, but I can now if you'd like me to.
Let's move on to the blood spatter found at the scene. You stated the photographs of blood droplets and the blood trail. Sorry, let me restate that. You reviewed the photographs of blood droplets and the blood trail found at the scene, correct?
Yes, I incorporated them into my analysis and reconstruction.
These pictures were later lost at some point in the investigation?
Yes, they were lost well after my review of them.
So part of your opinion was based off of pictures that cannot be seen here in court today?
Well, I would like to stress that I did visit the scene of the crime, so I was able to view this evidence for myself. I saw the blood droplets leading from the kitchen table to the front door, and I saw the blood cast off from Brackman pulling out the knife. So although the jury can't review these photos today, I can say they were definitely there.
So to your knowledge, you were the only one that reviewed those photos before they were lost?
No, I wasn't the only one that reviewed those photos. Other members of the crime lab definitely reviewed those photos.
Let's move on. Your Honor, permission for the witness to view Exhibit 6?
Yes, go ahead.
Let the record reflect, I'm showing the witness what has previously been marked as Exhibit 6. Ms. Cusack, do you recognize Exhibit 6?
Ms. Johnson, I cannot see Exhibit 6 on the screen, if that's what you're asking.
My bad, one moment. Are you able to see it now?
One moment, it's loading. Yes, now I'm able to see it.
Okay. Ms. Cusack, do you recognize Exhibit 6?
Yes, I do.
What is Exhibit 6?
It is a photo taken of the knife recovered from the crime scene.
Is the exhibit you're reviewing a complete and accurate copy of the one you reviewed during your investigation?
Yes, it is.
How do you know?
I took this photo for myself.
Your Honor, I now move to admit Exhibit 6.
Any objection?
No objection, Your Honor.
All right, 6 is admitted.
Your Honor, permission to publish to the jury by sharing my screen.
You may publish.
I now show you what has been marked for identification as Exhibit number 6. This knife, identified as the murder weapon, was indeed a different brand of knife than the ones found in the knife block in Mr. Brackman's kitchen, correct?
Yes, it was, but it's not unusual to have a different brand of knife in the same knife block. The missing knife slot actually had the same dimensions as the knife recovered from the crime scene, so it would most certainly have fit in that missing slot.
So that is a yes to my question?
Yes.
Was the idea that the suspect could have brought the weapon into Mr. Brackman's home ever really deeply considered?
I did consider this possibility, but I dismissed this theory since, again, there was a knife block with a missing knife slot and an open knife drawer. Also, Mr. Brackman was alerted to the intruder's presence and would have grabbed the knife for himself. So it came from Mr. Brackman's house.
Let the record reflect that I have stopped sharing my screen. Let's move on. The intruder was wearing gloves, correct?
Yes.
So there was no DNA found at the scene besides that of Mr. Brackman's?
No, there was no DNA found of the intruder, only Mr. Brackman, but that would be consistent with the fact that the intruder was wearing gloves.
Thank you, Your Honor. No further questions.
Any redirect?
Before I begin, may I ask for a brief time check, Your Honor?
Yes, you have 42 seconds.
Ms. Cusack, when were the photos of the blood splatter cast off lost?
Well, after my review.
No further questions, Your Honor.
Okay, thank you. May this witness be excused? No objection. Any further witnesses for the prosecution?
No, Your Honor. The prosecution rests its case in chief.
Okay, thank you. All right, does the defense wish to present its case at this time?
Yes, Your Honor. The defense wishes to call Avery Becker to the stand.
All right, go ahead.
Good afternoon, Mr. Becker. Please state your name and spell your last for the record.
My name is Avery Becker, Becker.
Why are you here today?
I'm being unfairly accused of murdering Mr. Brackman.
Let's start by talking about Mr. Brackman. How did you and Mr. Brackman know each other?
He was my mock trial coach for all 3 years of high school.
How was your relationship with Mr. Brackman?
It was like a family relationship where we spent a lot of time together because I love mock trial and I spent a lot of time in mock trial. And so like any family relationship, we had a lot of arguments, but we also had a lot of good times as well. Usually our arguments would be about my work ethic. He would say that I didn't put enough work into my crosses and directs, even though I won awards from them. And it was just because I had a different style than him. And it was discouraging to hear that he did not approve of my style.
Did you have any other opinions about Mr. Brackman?
I thought he was a good coach. He brought our team to a position where we were able to be competitive. We were able to compete in tournaments and win awards. And I really appreciate him and respect him for that.
Let's talk a little bit about the vandalizing incident. Did you ever mend things with Mr. Brackman?
I tried to meet him at his office, but was unsuccessful.
Foundation.
Response?
Sorry, could I hear the objection again?
Lack of foundation.
Your Honor, I'm just simply referring to the vandalization, which has already been talked about here in court today, and how Avery Becker handled the situation.
Overruled. Go ahead.
May I re-ask the question?
You may.
Did you ever mend things with Mr. Brackman?
I attempted to meet him at his office, but was unsuccessful.
Did you go to any other lengths to apologize?
I sent him a text, but I got no reply.
How did you feel after realizing you'd used a permanent marker by mistake?
I really regretted what I had done. I didn't think the damage would be permanent. I thought it would just be temporary, and I wasn't really thinking about what I was doing. And I just wished that he was still alive so I could properly apologize to him.
What was mentioned in the text you sent him?
I apologized sincerely. I said that I would get a job to pay for a new coat of paint or work really hard to try and scrub it off. And then I, again, told him that it was just I thought it was just a dry erase marker and it wasn't going to be permanent damage, but I got no reply.
Let's talk about March 5th, the day before Mr. Brackman was murdered. What did you do on March 5th?
After school, Taylor and I went to the Fry Shack and we played games on our phones.
Who did you see at the Fry Shack?
I saw a bunch of other mock trial students, including Alex Cifuentes.
Who is Alex Cifuentes?
Alex is another student at our school and is also a member of mock trial.
Did the two of you interact at the Fry Shack?
Yeah, I let Alex borrow my phone.
Were you friends with Alex?
No, we were more enemies than friends since Alex was always trying to take the #1 spot on the team and take the awards.
What happened at the Fry Shack?
Somehow I lost my phone. I don't know how, but I lost it.
When did you realize your phone was missing?
I realized it the next morning.
What did you do after finding out that your phone was missing?
Well, Taylor and I went and we searched around the mall and the Fry Shack to try and find it, but we couldn't find it anywhere, even if we tried calling it.
What happened when you tried to call the phone?
It would go straight to voicemail, meaning that it was either dead or stolen.
Who would have had the opportunity to steal your phone?
Well, Alex Cifuentes would have had the perfect opportunity since
Objection.
Alex.
Speculation, Your Honor.
Response?
Your Honor, this testimony actually falls under Proper Lay Opinion Rule 701. The statement is rationally based on the witness's perception of what happened.
Your Honor, may I please respond?
You may.
There hasn't been testimony to this statement being rationally based on the witness's perception, because the witness themselves has testified that there is a full restaurant of people. There's not enough foundation laid, and furthermore, there's not enough evidence given that this witness can testify to what they're testifying to.
All right, well, I do believe that this witness testified that Mr. Cifuentes handled the telephone, so I'm going to overrule the objection. Go ahead.
Your Honor, may I re-ask the question?
Yes.
Who would have had the opportunity to steal your phone?
Well, Alex Cifuentes would have had the perfect opportunity since I let her borrow my phone at the price check.
What happened regarding Alex and your phone?
Well, Alex claims to have received texts from me asking for help getting back on the mock trial team. And I would not go to Alex for help. As I said, we're more enemies than friends. And, if I was off the team, Alex would win awards. So I don't know, she wouldn't help me get back on the team anyways.
Are there any other texts you supposedly sent to Ms. Cifuentes?
Alex also claims to have received a text saying that I was going to trash Mr. Brackman's house, which is just way too far. I would never trash his house. That is just completely irrational.
Would you text Alex in a situation such as this?
No, I wouldn't ask Alex for help. Alex would be the last person I would ask for help.
Let's talk about Blair Rollins. Who is Blair Rollins?
Blair is another student at our school.
How do you know Blair?
Well, from what I understand, Alex and Blair are friends.
How is Blair relevant to the case?
Well, Blair's father was represented by Mr. Brackman in court, and Mr. Brackman lost the case, getting Blair's father thrown into jail.
What information do you have regarding Blair, Alex, and your cell phone?
Well, I think that Blair and Alex tried to set me up. If they could make it look like I trashed Mr. Brackman's house, Alex would be able to make sure that I would never get back on the team and would be able to win all the awards at all the tournaments.
Objection, Your Honor. Speculation.
Response.
Once again, Your Honor, this falls under Proper Lay Opinion Rule 701. This is rationally based on my witness's perception about what happened to his phone after it was stolen by Alex in regards to what has already been testified about, not only Blair Rollins, but also the relationship between Blair and Alex.
All right. This witness is a defendant in the case. I'll allow him to testify to his theory of how this incident occurred. So overruled.
May I re-ask the question?
You may.
What information do you have regarding Blair, Alex, and your cell phone?
I think Alex and Blair tried to set me up to make it look like I had trashed Mr. Brackman's house, because if they did successfully, then I would not be able to come back to the mock trial team, and Alex would be able to win all the awards at regionals and state.
What similarities do you share with Blair Rollins?
We're about the same height and build.
What do you know about Blair's current whereabouts?
To my knowledge, Blair has not been seen since Mr. Brackman's murder.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. You testified on direct that Alex Cifuentes had possession of your phone on March 5th.
Yes, I let her borrow my phone at the fry shack.
Do you remember giving a sworn statement in this case, Mr. Becker?
Yes.
And you signed this statement understanding that you must include everything that you knew that could be relevant to this event you discussed?
That is correct.
And you were testifying that Alex took your phone on direct today, had possession of your phone today on March 5th, correct?
That is correct.
Your Honor, permission for me to screen share this witness's affidavit?
Any objection? All right, no objection.
No objection, Your Honor.
All right, so you may share. Go ahead.
Mr. Becker, can you see your affidavit?
Yep.
Just a moment. This is a true oh, sorry, I apologize. That's not your affidavit. This is a true and authentic copy of your affidavit?
It looks so.
Mr. Becker, I'm going to need a yes or no.
Yes, sorry.
And this is your signature at the bottom.
That is correct.
Mr. Becker, can you please point to me where you state Alex Cifuentes took your phone? I mean, had access to your phone on March 5th?
I am not sure I mentioned it in my affidavit.
Objection, Your Honor. We've already established that the testimony my witness made fell under proper lay opinion, Rule 701.
Well, I'm more concerned about Rules 613. Just ask the witness if he made certain statements. Don't show the written statement itself.
Your Honor, I'm impeaching by osmosis.
By what? Omission? Okay.
Yes, excuse me. I apologize.
Just ask him if he made the statement. If he didn't make the statement, then you've got your answer.
I see. Mr. Becker, is this statement in your affidavit?
I do not believe so.
All right, let's move on. You had a rocky relationship with Brackman?
Yeah, you could say that. It was like a family relationship where we got into a lot of arguments. But we also had plenty of good times.
And you were often angry with Mr. Brackman?
Yeah, arguments can make you angry.
And Mr. Brackman hated you?
At times it felt like that.
And in fact, you would argue at every practice?
Yeah, like I said, we would argue often, but we also had plenty of good times.
And you believed Mr. Brackman was a lousy attorney?
Yeah, I felt like he spent too much time on mock trial and didn't put enough work into his actual job.
And you left practice after an intense dispute with Brackman during mock trial?
Yeah, that's correct.
And you wrote worst attorney award in permanent marker on Brackman's car when you stormed out of practice, correct?
Yeah, I wasn't thinking, I was really angry. I didn't know it was permanent marker. I wish I had known it was, because then I wouldn't have done it. But yeah, I really regret my actions.
And you knew Brackman loved his Porsche before this incident, correct?
That is correct.
And you had the marker in your hand before you stormed out of practice?
That is correct. I was going to write on the whiteboard.
Hold on a minute. Your initial plan was to write on the whiteboard with permanent marker.
Well, like I said, I didn't think it was permanent marker. I thought it was dry erase marker.
And after you got kicked off the team, you told your mom I would get back at him if it was the last thing I did.
Yeah, I really wanted to get back on the team. And I was just, really sad that I was off the team. I was really angry. Of course, I didn't mean anything by that.
And the first emotion you felt when Coach Brackman kicked you off the team was anger?
I mean, mock trial is my life. I've spent so much time on mock trial. Mock trial is my passion. And so I'm understandably mad
Mr.
when
Becker,
I get kicked off the team.
Mr. Becker, I'm not asking about how much you love mock trial. I'm asking if the first emotion you felt when Coach Brackman kicked you off the team was anger. Also, I do apologize for interrupting you.
Yeah.
Okay, let's move on. And you played video games on your phone at the Fry Shack, and then you went to the mall and walked around on March 5th, the whole mall.
Objection,
yeah.
Your Honor, compound question.
Response.
Your Honor, I don't believe my question was compound. I just added the whole mall. I didn't.
Just rephrase the question.
Okay. You played video games on your phone at the Fry Shack, and then you walked around the whole mall on March 5th.
That is correct.
And you claim you lost your phone on March 5th, and you didn't notice your phone was missing till March 6th.
That is correct.
Objection, Your Honor, once again, compound question.
You want to respond?
May I break up my question?
You may.
you claim you lost your phone on March 5th,
That is correct.
and you didn't notice your phone was missing till March 6th.
Yeah, I didn't need to use it all that evening of March 5th.
In fact, you ditched school on March 6th to look for your phone.
Yeah, Taylor and I didn't have first period, and we didn't think it would take long to find it. So, yeah, we just went and tried to find it.
And you are the same general size and build as the perpetrator in the ring footage, correct?
That is correct.
And Taylor Perkins quit the mock trial team so you could get back on A team.
That is correct.
And you were, as you put it, best buds with Taylor Perkins.
Yeah, we've been best friends for a while.
No further questions, Your Honor.
Okay, thank you. Redirect?
No redirect, Your Honor.
All right, may this witness be excused then? All right, no objection. Defense wish to call any additional witnesses?
Yes, Your Honor, the defense wishes to call Taylor Perkins to the stand at this time.
Okay, thank you.
Good afternoon, Ms. Perkins. Please state your name and spell your last for the record.
My name is Taylor Perkins, Perkins.
Ms. Perkins, how do you know the victim, Mackenzie Brackman?
Mr. Brackman was my mock trial coach when I was in high school.
And how do you know the defendant, Avery Becker?
Avery Becker and I are close friends, and we spent a lot of time on mock trial together.
Based on your observations, how would you describe the interactions between Mr. Becker and Mr. Brackman?
Well, they bickered a lot, mostly over Avery's work ethic for mock trial and preparation.
How would you characterize their relationship?
Well, like I said, they had quite a few disagreements, but it didn't seem like anything out of the ordinary for a coach-student relationship to me. I really found it kind of funny.
Why do you believe that Mr. Brackman and Mr. Becker got into conflicts?
I believe Mr. Brackman had a hard time with how naturally talented Avery was at mock trial. I mean, Avery didn't need to put in that much effort because it just came so naturally to him.
What were some of the consequences of their ongoing conflict?
Well, one of the biggest consequences that affected me personally was that at a practice before the regional tournament, Coach Brackman removed Avery from the A team of mock trial.
What did you do when Avery was removed from the A team?
Well, I thought it was really unfair. Avery had been a part of mock trial for 4 years, and it's his passion. And I don't have that same passion for mock trial. I don't even want to be a lawyer. So I removed myself from the A team so that Coach Brackman would have no choice but to put Avery back on.
Ms. Perkins, after you stepped down from the team, how did they perform at regionals?
They did really well. Avery got a couple awards, and it just goes to show that I made the right decision.
Ms. Perkins, Avery Becker just testified on direct about the events that caused him to be removed from the mock trial team completely. Did you and Avery speak about those events?
We did. That evening, we spoke about them.
What did you and Avery discuss about these events?
Well, we discussed ways for Avery to get back on the team, which included messaging other members of the team to see if they could reach out to Coach Brackman for Avery.
How did you perceive Avery to feel in these discussions?
Remorseful.
My apologies. Let's talk about March 5th, 2020. That is the night before Mr. Brackman was killed. Did you see Avery that day?
I did. Avery came to my house that evening.
What did you and Mr. Becker do that day?
So Avery came to my house, we played some video games, and then we got hungry, so we went to the Fry Shack after.
Who else was at the Fry Shack that night?
Most of the mock trial team was there, including one of Avery's least favorite people, Alex Cifuentes.
How do you know Alex Cifuentes?
Alex was also on the mock trial team. They were a year younger than us, me and Avery. So neither of us were really close to Alex.
What was the interaction like with Alex Cifuentes that particular night?
Well, Alex seemed kind of insincere in expressing how they thought it was unfair that Avery got kicked off the team. So understandably,
Hearsay?
Hearsay?
Yes, Your Honor.
Any response?
Your Honor, the witness is describing something that, as they immediately perceived it, which is admissible under 803.1, as well as the fact that there is 803.3, which is then existing emotional, mental, and physical condition, which would be anything for Avery Becker's statements.
Any reply? All right, I'm going to overrule the objection. I didn't hear any hearsay.
I
All right,
apologize.
go ahead.
I was on mute.
Go ahead.
It's all right, Your Honor. I was asking for a moment.
All right.
My apologies with that objection over.
Next question.
Ms. Perkins, what did Avery do after this interaction?
Avery stormed off to the bathroom.
When did you and Mr. Becker leave the Fry Shack?
We left immediately after Avery came back from the bathroom and we went to the mall.
Where was Mr. Becker's phone when you left the Fry Shack?
Well, I remembered Avery leaving his phone on the table when he went to the bathroom, but I didn't remember him picking it up on our way out, so I believe it was there.
What happened the next morning? That would be March 6th, 2020.
Yeah, that morning started out like every other morning. Avery came and picked me up for school.
Is it common for you to get a ride from Avery to school?
Yeah, we rode to school together a lot.
Did Avery have his phone with him that morning?
No, I had tried to contact Avery that morning just to clarify that he was picking me up, and I hadn't heard anything. So when he showed up at my house, I just kind of jokingly mentioned like, hey, I didn't hear from you. And that's when we realized that he didn't have his phone.
What did you do after realizing Mr. Becker's phone was missing?
We decided that we would retrace our steps from the night before to look for it.
Were you able to find Avery's phone?
No, unfortunately, we weren't able to.
Ms. Perkins, were you with Mr. Becker for the majority of the day on March 6th, 2020?
Yes, definitely.
Who saw you and Mr. Becker together that day?
Well, like I said, we retraced our steps from the night before. So we went to the mall and we went back to the Fry Shack for both the morning and afternoon shift. So we were in public places all day, as well as that afternoon when we were at the Fry Shack, we saw members of the mock trial again. So they would have seen us as well.
When did you find out that Mr. Brackman had been killed?
I found out later after I had seen members of the mock trial at Fry Shack at the same time as everyone else.
Let's move on and discuss Blair Rollins. Ms. Perkins, who is Blair Rollins?
Blair Rollins was also a student at CHS.
Who was Blair Rollins friends with?
From what I could tell, Blair Rollins and Alex Cifuentes were close.
Is there any connection you're aware of between Mr. Brackman and Mr. Rollins?
Actually, yes. It was pretty common knowledge at our high school that Coach Brackman had represented Blair's dad in a court case that got him sent to jail. So there's that connection.
Ms. Perkins, have you seen Blair Rollins since Mr. Brackman was killed?
I haven't, and I don't believe anyone else has either.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Perkins. Let's begin by discussing the defendant. The defendant is your best friend, correct?
Correct.
The defendant and Mr. Brackman had an ongoing conflict?
They had some disagreements, yes.
Mr. Brackman upset the defendant?
Yes.
In response to a particularly heated argument, the defendant vandalized Mr. Brackman's vehicle with a permanent marker?
That is true, but Avery thought it was a dry erase marker. He didn't mean to use a permanent marker.
Mr. Brackman then kicked the defendant off the mock trial team?
Yes.
In an attempt to get back on the mock trial team, the defendant texted everyone on the team?
I do believe so.
Including Alex Cifuentes?
I think so.
After school that Thursday, Mr. Brackman told the defendant to leave after he had tried to convince him to let him back on the team?
Yes.
Mr. Brackman was found dead the very next day.
Objection, Your Honor, relevance to the previous questions.
Overruled. Go ahead. You can ask your question.
Ms. Perkins, I'm going to re-ask that question. Mr. Brackman was found dead the very next day.
That is true.
Let's clear up a few things about the defendant's phone, Ms. Perkins. The defendant had a habit of having his phone with him.
Yes, like every other teenager.
Like his third kidney, as you put it.
I did say that.
After leaving the Fry Shack on March 5th, you weren't sure whether the defendant had grabbed his phone, correct?
That's correct. I saw him leave it on the table.
You went to the mall with the defendant after leaving the Fry Shack.
Yes.
At no point while at the mall did the defendant appear to realize that his phone was missing?
No, we were busy hanging out at the mall. Avery didn't need it.
He didn't need his third kidney?
Well,
more prejudicial than probative under Rule 403.
Your Honor,
This is cross-examination. It's overruled.
the next morning, the defendant wasn't answering your texts about whether you were going to school together?
Yeah.
You were still able to meet up to go to school together without this communication?
Yes. Well, like I said, it was a common occurrence for Avery to pick me up for school, so I wasn't too worried when I hadn't heard back.
You were the one to point out that the defendant hadn't been using his phone.
I was.
That's when you realized the defendant's phone was missing.
Yes.
At no point during the night after the defendant left the Fry Shack did he notice that his phone, his third kidney, was missing?
No. And like I said, we were busy for most of the evening, so he didn't need it.
At no point during the morning of March 6th, when he wound up at your house, did he notice that his phone, his third kidney, was missing?
No.
You spent an entire day looking for a phone?
We did. I mean, we all use our phones so much. They're very important, so we thought it was important to find Avery's phone.
Ditched all your classes?
Objection, Your Honor, relevance.
Overruled.
Sorry, can you re-ask the question?
Re-ask that question. You ditched all your classes?
We did. Like I said, we thought it was very important to find Avery's phone.
After spending the day going to every single store you had been to the night before, you suddenly remembered that the defendant might have left his phone on a table at the Fry Shack?
Yes.
During your search, you never thought to use iCloud or Find My iPhone to pinpoint the defendant's phone?
No, I had an Android phone, so using Find My iPhone wasn't a program I was familiar with.
Finally, Ms. Perkins, I'd like to talk about your recollection of March 6th and Avery's recollection of March 6th. Your story matches with Avery's.
Yes, we spent the whole day together. Of course it would.
More specifically, you knew your stories matched when you gave a sworn statement ahead of today's trial.
Yes, like I said, we spent the whole day together. Of course they would match.
But you knew that your stories matched when you gave a sworn statement, to clarify?
I did.
You mentioned that your stories matched in that sworn statement.
I did.
No further questions, Your Honor.
Okay. Any redirect?
No redirect, Your Honor.
Okay. Thank you. May this witness be excused? All right. There being no objection. Any other witnesses for the defense?
Yes, Your Honor. I would like to call Professor Blake Van Owen to the stand. Your Honor, since I am the last direct, may I request a brief time check?
Yeah, let's do a time check.
Thank you. May I begin?
Yes.
Good evening. Please state your name and spell your last for the record.
Professor Blake Van Owen, VAN space OWEN.
What do you do for a living?
I am a professor, a private investigator, and an expert witness in police practices.
What is your educational background?
I have my master's degree in criminal justice at Ashford University, and I now teach classes on police procedures at Community College of the Rockies.
When did your experience with the law enforcement begin?
I'd say it began when I joined the Aurora Police Department. That department gave me a lot of experience, which has shaped me to be the person I am today, and to be able to give the expertise that I have.
Have you testified as an expert in court before?
Yes, I have consulted on more than 100 cases.
Which areas have you testified as an expert witness in?
My credentials have been found to be sufficient enough to be testified as to testify as an expert in the areas of crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Your Honor, at this time, I move to tender Professor Blake Van Owen as an expert in the field of police practices, crime scene reconstruction, and cell tower analysis on the grounds of her education, experience, and expertise.
Any objection?
No objection, Your Honor.
Okay, court will accept this witness as an expert in those three areas. Go ahead.
Let's start with the evidence found at the scene of the crime. Did you review Kyle Kuzak's report?
Yes, I did. I took issue with his analysis of the scuff marks and the murder weapon.
What was the issue with Kuzak's scuff mark analysis?
Well, I mean, we can all see that there were scuff marks on the floor. That was pretty clear. However, there is no clear evidence that points to the scuff marks being created during the incident. I mean, you can't carbon date scuff marks, so it's hard to tell.
What conclusions did Kuzak come to based on the knife's position?
Kuzak believes that Brackman and the intruder.
Objection, Your Honor. Hearsay.
Response?
Your Honor, she reviewed Kyle Kuzak's report as part of her investigation and knows what is within that report.
And also, experts are allowed to rely on hearsay, so overruled.
Your Honor, may I repeat my question?
You may.
What conclusions did Kuzak come to based on the knife's position?
Kuzak believes that the intruder and Brackman were engaged in a scuffle, in which the intruder stabbed Brackman in a downward angle to nick his aorta. This would mean that the intruder would have to be taller than Brackman, and if we look at the ring videos, it is clear that that is not the case.
Your Honor, permission for the witness to view Exhibit 21.
Any objection? 21's been admitted. 21 has been admitted, correct?
Let the record reflect I am showing the witness what has previously been marked as Exhibit 21. Do you recognize this exhibit?
Yes, I do.
What is it?
It is a photograph of a hand holding a knife in a position that appears to be very comfortable and natural just based on the way the knife's handle is constructed.
The exhibit you are viewing a complete and accurate copy of the copy you reviewed in your investigation?
Yes, it is.
How do you know?
Because this is the photograph that I used for my examination.
Your Honor, I move to admit Exhibit 21.
Any objection?
No objection, Your Honor.
21
Your
is
Honor.
admitted.
My apologies. Your Honor, permission to publish to the jury by sharing my screen.
You may.
I now show you what has been marked for identification as exhibit number 21. What does this picture mean to the investigation?
Well, most people will just naturally hold this knife in the same manner, no matter how they're going to use it. Just the way that you pick up a knife is going to change based on the way that the knife's handle is constructed. And so it doesn't matter how you're going to use it. This is the grip that will feel most comfortable. And in order for an intruder to stab Brackman in a downward angle, as well as to nick his aorta, tells us that the intruder would have to be much larger than Brackman, as I previously stated.
Let the record reflect I have stopped sharing my screen. Now let's talk about the Ring Security app. What experience, if any, do you have with the Ring Security app?
I own this app myself, and I would say I'm pretty familiar with its capabilities.
What are some of the owner's abilities throughout the app?
One of the ones that I use a lot is the ability to turn on and off notifications. This is incredibly helpful during the holiday season when you're getting so many packages and you don't want all those notifications on your phone.
Do you know if Mr. Brackman's security system had this option?
Every system should have this ability.
Where do you believe Avery Becker's phone was at the time of the murder?
Based on the cell tower analysis that I have reviewed, it appears that his phone was in the general area of Mr. Brackman's home. However, cell tower analysis is very different from GPS data.
How is GPS data different from cell tower data?
Well, GPS data will give you an exact location, a pinpoint of where the phone is. Cell tower analysis, however, is a bit more vague in that, your phone will connect to whichever tower gives it the best connection. And so that tower might be right next to you, or it might be 10 miles away. It just depends on whoever else is in your area and what the connectivity is like. So cell tower analysis will give us the general area of where a phone's location is, but it won't tell us specifically where it is at any given time.
What does this prove?
Well, this shows that, even if Avery Becker's phone was in the general area of Mr. Brackman's home, it doesn't prove that it was at his home. And further, Avery Becker has stated that he lost his phone the day of the murder. So even if his phone was at Mr. Brackman's home, it doesn't prove that Avery Becker himself was there.
Do you know if Detective Markowitz had access to cell phone records?
Yes, he did.
What do you believe Detective Markowitz should have done with this opportunity?
Well, he should have collected all of the cell tower records for the days prior to the murder and the day of the murder, not just the specific date and time that he did. And he also should have looked into people who had connections to the victim and obtained their cell tower records as well.
What did police have access to at the time of the murder?
Police almost always have access to Celebrite, which is a mobile forensic software that allows them to very easily download the contents of any cell phone, and that would include text messages.
What did the police do with this software?
Well, unfortunately, instead of using it, they just accepted Alex Cifuentes' screenshots, which could have been easily doctored.
Why is obtaining the actual contents of a cell phone more important than just the screenshots alone?
Because they have this ability and this software available to them, it's a more professional thing to do, especially if it was an option, which it was.
What do you believe that the police should have done with this instead?
The police should have obtained Alex Cifuentes' phone and used the Celebrite software to download the text messages.
What other suspects did the police question?
The police didn't question any other suspects.
Who had more of a motive in this case than Avery Becker?
I believe Blair Rollins might have.
Who is Blair Rollins?
Blair Rollins is the son of Jonathan Rollins, and he was represented by Brackman in a case for murder in which he was convicted.
What evidence did you find of Blair Rollins' motive?
Well, as Blair's father, Jonathan Rollins, was being let out of the courtroom, he called out to Brackman that he would get him back.
What is Exhibit 22?
It is an audio recording of the court proceedings in which Jonathan Rollins was convicted.
How do you know?
This is the recording that I reviewed when making my examination.
Have you personally reviewed the audio labeled Exhibit 22?
Yes, I have.
To your knowledge, has a copy of Exhibit 22 been provided to the prosecution counsel?
Yes.
Is Exhibit 22 a complete and accurate copy of the audio you retrieved during your investigation?
Yes.
Your Honor, I move to admit Exhibit 22.
Any objection?
No objection, Your Honor.
Your Honor, permission to share my screen and publish Exhibit 22 to the jury by playing the audio.
Exhibit 22 will be admitted and you will be allowed to publish.
I'll get you back, Brackman, if it's the last thing I do.
Let the record reflect I have stopped playing Exhibit 22. What do you conclude of this recording, Professor Van Owen?
I mean, I'd say that Jonathan Rollins was pretty serious when he said that, and so the threat that he made could have been credible.
Now, let's talk about the day Mr. Brackman was murdered. What else did you review during your investigation?
I also looked at Blair Rollins' attendance records.
What did you find when reviewing Blair Rollins' school attendance records?
I found that he was absent the day of the murder, and that would have allowed him to go to Brackman's house.
What do you know about Blair's whereabouts today?
Well, unfortunately, we don't know where he is or how to contact him.
What motive would Blair Rollins have to harm Mr. Brackman?
I mean, in my opinion, having your father be put away for murder is a much higher motive than just being kicked off of the mock trial team.
Finally, in your expert opinion, do you believe Avery Becker, the defendant, killed Mr. Brackman?
No, I do not.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Professor Van Owen. Let's begin with your relationship with law enforcement. You're a seasoned expert witness for the defense?
I am. I consider it to be a strength of mine. As I was a police officer, I have the training that a lot of the experts for the prosecution have, and so I'm able to provide that for the defense.
In fact, you only testify as an expert witness for the defense.
That's not quite by choice. Because the prosecution has access to police, they typically go with them.
Professor Van Owen,
yes.
Is that a yes or a no to my question?
Yes.
You, in fact, said you make a decent living revealing where police drop the ball.
This is my part-time job. I'm also a professor, and all expert witnesses get paid for their testimony.
Is that a yes or a no to my question, that you make a decent living revealing where police drop the ball?
That is a yes.
You, in fact, consider yourself a check on the power of the police.
I believe that it is important to examine the police system.
Is that a yes or a no to my question?
Can you please repeat your question?
You consider yourself to be a check on the power of the police?
Yes, I do.
You agree that physical on-scene evidence points to an intruder who broke into the home of the victim, Mackenzie Brackman?
Yes.
Also, you agree that the cell tower records show that Avery Becker's phone communicated with a cell tower near Mackenzie Brackman's home?
Yes, that's correct.
You also stated in your direct that the phone was in the area of Brackman's home.
According to the cell tower analysis, it did appear to be connecting towers in the general area of Mr. Brackman's home.
Is that a yes or a no to my question?
That would be a yes.
You take issue with the scuff marks at the scene of the crime?
Yes, I do.
Because they can't be carbon dated?
Yes, that's correct.
You believe cell tower data to be unreliable?
I don't believe it to be unreliable. I just believe that it's not quite as accurate as GPS data would be.
So you believe that cell tower data is not accurate?
No, it is accurate. I think that the way that it has been used in this investigation doesn't quite work with how it is supposed to be used.
You disagree that the victim and intruder were wrestling for control of the knife?
I believe that it was like a sneak attack. So I don't believe that there was a scuffle.
So do you disagree that the victim and intruder were wrestling for control of the knife?
Yes, I disagree.
You stated that when people grab a knife to stab down, most of them hold it with the blade pointing toward the ground where the knife is raised.
Yes, I did state that.
Additionally, for an intruder to stab Brackman in a downward angle and still nick Brackman's aorta, especially if both are standing, the intruder would have to be a much bigger person than Brackman.
Yes, I also stated that.
This fits the police narrative?
It does, yes.
You stated that it would be beneficial for your case to get the defendant's cell records the day before the crime.
Yes, I believe as much evidence as possible would be beneficial.
Yet, you stated that you failed to do this.
Yes, unfortunately, I did overlook that, and I regret that.
Jonathan Rollins made the statement in Exhibit 22?
Yes, he did.
Not Blair Rollins?
No, Jonathan Rollins is Blair's father.
So not Blair Rollins?
No, not Blair Rollins.
Alex Fuentes was friends with with Blair Rollins?
I don't have knowledge to that. I'm sorry.
You don't have knowledge to whether Alex Fuentes was friends with Blair Rollins?
I don't believe it's in my affidavit.
Okay. Thank you, Your Honor. No further questions.
Any redirect?
No, Your Honor. The defense rests its case.
Okay. And is there any rebuttal evidence from the prosecution?
Are you asking for a closing argument, Your Honor?
Is there any rebuttal evidence from the prosecution?
No, Your Honor.
Then are we ready for closing arguments? Let's hear from the prosecution.
Yes, Your Honor. Well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait until he's at work, then break in and trash it. That'll show him. What's seen in this case is a pattern of taking it a step too far. The defendant taking it a step too far, vandalizing Mackenzie Brackman's car. The defendant taking it another step too far, planning to burglarize Mackenzie Brackman's house. And the defendant taking it a tragic and fatal step too far, with this attempted burglary leading to Mackenzie Brackman's death. The defendant has been charged with second-degree burglary and felony murder. By committing second-degree burglary and this resulting in another's death, the defendant has committed felony murder. The defendant must have broken entrance into Mackenzie Brackman's home and then remained unlawfully to commit criminal mischief, this being to plan to vandalize Mackenzie Brackman's home. There is evidence of Becker's phone at the scene of the crime, concrete evidence linking the defendant to the crime from 105 to 115 in cell tower records. Records that Professor Van Owen says are not inaccurate. There is someone the same height and build as the defendant at the scene of the crime. Even Van Owen states that the phone was in the area of Brackman's home. After committing second-degree burglary, the defendant must have, while committing or attempting to commit second-degree burglary or in the flight from the residence, caused the death of another person. Mackenzie Brackman was alerted to the intruder through the Ring security system. Markowitz downloaded the contents of Brackman's phone, including Ring security data. He then took a knife, the exact same height and dimensions as the spot in the knife block that it was from. A scuffle occurred, resulting in a broken plate and scuff marks and exhibits 9, and 18. The knife, once removed from the victim's shoulder, caused him to bleed out and die. By committing second-degree burglary, the burglary going wrong leading to Mackenzie Brackman's death, the defendant has committed felony murder. As Kyle Kuzak told you, this was a burglary gone wrong, where the intruder knew the victim's property and residence and likely chose a time of day when the victim's pattern would have placed him outside of the home. But the victim was present and was to the intruder's presence. And in an ensuing struggle, the victim was killed by the same knife he introduced into the encounter. Of course, one piece of evidence is not enough to convict someone and does not tell the whole truth, but it's the accumulation of evidence and how it fits together that shows the truth. The prosecution has brought you physical, concrete evidence and brought you a case backed up by this evidence. When you deliberate, ask yourself, do actions or a dramatic event prove guilt? Does physical evidence link someone to a crime or gossip of another person's connection? As my co-counsel has informed you today, the prosecution has a burden of proof. The burden of proof being beyond a reasonable doubt. Reasonable doubt is anything that causes a reasonable person to hesitate in matters of importance. If any piece of evidence causes you reasonable doubt, you must acquit. In opening statement, opposing counsel stated that the prosecution's evidence is circumstantial. I will remind you of jury instruction number 3. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Remember this, and do not let the defense lead you to disregard evidence. With all of the evidence brought before you today, the prosecution asks you to hold the defendant accountable and find him guilty of second-degree burglary of a dwelling and felony murder.
Thank you. And the defense?
Today, members of the jury, you have been presented with a heavy case. The most important thing I hope you take with you as you come to a consensus is that we have an innocent young man standing before all of us, facing an accusation he absolutely does not deserve. The fact that there is a surplus of holes and misalignments in this case should prove to you the unfairness of this investigation, let alone the suspect that came out of it. A chain is only ever as strong as its weakest link, and this investigation is a prime example of that. Avery Becker may have had a few disputes with his coach, may have taken things a bit too far at times, but to assume that this high school student is capable of murder simply because of a few misunderstandings is a reach that could cost Avery his future, let alone cost the true justice that Brackman deserves. In this case, Avery Becker was that weak link. The investigation done on Avery was biased from the start. Instead of investigating all possibilities and then choosing their suspect when there was absolutely nothing left to consider, they chose their suspect first thing and built their case around that. Today, you heard Detective Markowitz, confident in her 3-day training, allow emailed screenshots to be used as evidence in a murder case. Screenshots that were sent an entire day after their interview. The credibility of these text messages would increase by tenfold had Markowitz downloaded the messages off of Alex's phone using the software available to her. But even after Alex supposedly offered to bring her phone in, Markowitz neglected to do so. You heard Kyle Kuzak explain to you his investigative process, a process that apparently didn't push him to take any steps into investigating Blair Rollins. You heard Alex Cifuentes go on about how she and Avery were such good friends, yet no other witness claims such a thing. Has anyone considered the possibility that Alex and Blair had used the misunderstandings between Avery Becker and Mr. Brackman to their advantage? To distract from Blair and his involvement in the case? The police certainly didn't. You, however, should. You heard from Avery Becker, a talented and devoted student who wanted nothing more than to bring success to his mock trial team, and ended up suspect for crimes he didn't commit. Is there solid proof that the person who broke into Brackman's home and murdered him was Avery Becker? Can anyone testify that they saw his face in the ring footage? No. So why was the police so quick and eager to label him their suspect? The prosecution describes Avery as unrelenting in nature, but Avery Becker sat here today and told you of his efforts to apologize to his coach. The immense regret Avery felt is not characteristic of someone who is supposedly so unrelenting. Instead of taking things a step further, as the prosecution described, Avery took a step back, understanding that he took things too far in vandalizing Brackman's vehicle and doing whatever he could to make things right. You heard from Taylor Perkins, the very person who was with Avery on the day of the murder, and has told you exactly what happened surrounding that time. They were searching for Avery's stolen phone. Finally, you heard from our own private investigator, Blake Van Owen, who explained how rushed this investigation was. You heard of the lack of support behind many of Kuzak's claims and the lack of accuracy behind Markowitz's cell tower data. He also supports the notion that the detectives chose their suspect at the beginning, then sought out evidence that matched with it. I hope we have proved to you beyond a reasonable doubt how those who ran this investigation did so in a lazy and unprofessional manner. The prosecution has the burden of proof, and I hope you'll consider whether or not they truly met that burden. Did they make you believe that Avery Becker is undoubtedly guilty? Can you say with absolute certainty that Avery committed these crimes? Take Alex Cifuentes as an example of how rushed this investigation was. The student couldn't even provide her phone on the day of her interview, a phone that supposedly held incriminating evidence. Take Blair Rollins as a second example. There is no doubt that Blair Rollins has involvement in this case, not to mention a motive, and yet nothing in relation was investigated. Once again, a chain is only ever as strong as its weakest link. How can you possibly convict someone without absolute certainty, without each and every possibility thoroughly investigated? A rushed investigation isn't going to cut it, especially a murder investigation and one that involves high school students. The chain of this investigation became weak the second they latched onto Avery Becker. Each link that came after that had only one purpose: to strengthen the credibility of Avery, the weakest link. However, you as the jury should now be well aware of this manipulation. The detectives' intentions are crystal clear. They never intended to solve this case and bring justice to a deceased man. They intended to do things the easy way, latch onto a suspect and roll with it, ignore outside possibilities, and get things done as quickly and easily as possible. Detectives who are true to their title would never handle things the way this case was handled. Every little detail must be taken into consideration. No subpar evidence should make the cut. The prosecution has tried to prove to you that it was Avery Becker behind that mask. But ladies and gentlemen, it is now your responsibility to see through this inadequate investigation and vote in favor of the defense. Thank you.
Thank you. All right, I think that the case is closed.
My apologies. Yes. In preliminary matters, we asked for time for rebuttal after closing if time permitted. Do we have the go-ahead to do that, or?
How much time do we have left for rebuttal?
Has 1 minute.
It's too late for rebuttal. I mean, well, for rebuttal close, Yeah, okay, that's fine. How much time do we have left?
It's going to be 1 minute and 15 seconds.
All right, go ahead.
The police did look into all possibilities. Markowitz told you today that the police looked into Blair Rollins. Blair Rollins' residence being on the cell tower data in Exhibit 15. The defense has brought Blair Rollins as a suspect because of an audio recording of a threat made against Brackman. This statement was not even Blair's. The defendant, and not Blair Rollins, is before you today because there is more concrete evidence linking the defendant to the crime. A weak link is a questionable alibi. The defendant's phone was missing, but does someone spend an entire day ditching school to search for their phone, their third kidney, without ever using Find My iPhone to locate it? Does someone still not even have this phone to this day? That is a weak link.
Okay, thank you. All right, I think that the case is now closed. Is that right? And now we need to have the scorers do whatever scorers do. So can I have, is Dawn Rogers available right now?
Yes, Your Honor.
Okay, what do we need to do at this point?
So we just need to get the scoring panelists to submit their score sheets so that scores can be accounted for. And then when they've completed that, we can start with some feedback from the scoring panelists for the participants.
Okay.
In the meantime, Your Honor, if you wanted to provide feedback to the participants, I'm sure they would be delighted.
Sure, sure. Okay, well, first of all, let me say that you all did a very good job. I mean, I've been in this business now for over 40 years as a trial lawyer and a trial judge, and I can say that, you know, it was obvious that you guys prepared and took this project seriously. I thought your examinations were good. I thought the witnesses were excellent. There was, you know, some real personality there, and you stuck to your stories. It was, you know, obvious that you've had a lot of support from your coaches, from your parents, to get you to this point. So, you know, I think you should all thank them at this time, even though they're not here. Normally we do this in a courtroom where, you know, people can clap and talk to one another after the trial's over. A little unusual in these COVID times to you know, because we can't do that kind of thing. But I know that you all appreciate the support that you've received from your coaches and parents who've made sure that you got to practice on time. Any questions? I think I can ask the group generally if you have any questions of me. Is that right, Dawn?
Yes, Your Honor, that's fine.
Okay. So while we're waiting for the scorers, does anyone have any questions? You know, this is I can say this is it's hard. I mean, trial is hard in a courtroom, you know. It's especially hard, I think, when we're doing it over Zoom. You know, it's hard to kind of get the momentum and you know, but again, I thought you guys did an excellent job in that regard. You know, it'll be nice when we do finally get back into the courtroom. I just learned today that I guess we are now starting to try criminal cases, jury trials, which we haven't done for about a year. So it's nice that the lawyers are finally getting back into the courtroom. The judges are getting back into the courtroom with juries and trying these kinds of cases again, because they're important cases, both for the prosecution and certainly to the defense. So anybody have any questions of me? No? Okay, all right. It gets a little confusing sometimes with the exhibits, because sometimes I guess you guys stipulate to admissibility before we start, right? Is that correct? And then I see you guys then trying to lay foundations during the trial itself to admit, and then asking to admit exhibits. And that kind of confused me a little bit. I mean, if an exhibit is admitted, it's admitted. You don't have to lay a foundation and move to admit it again. But I guess it is good experience for you to be able to lay those foundations, and that's probably why you do that. Even though I guess their admissibility is already stipulated too.
And Judge Cachette, I did just get notice that we have all of the scoring panelists' scoring sheets, so we are ready for them to provide feedback when you're ready.
Okay, all right. So it sounds like the scorers can give you feedback. Maybe we'll start with Emily Valdez, who's a public defender and has a lot of experience trying cases. Go ahead, Emily.
Thanks, Judge. So I'll start by talking about your in regards to openings and closings, and just kind of talking about them and how they kind of really, I felt like, connected from the beginning to the end, which was great. I loved that you both had solid themes and theories, and that you brought them back in again in the closing arguments. And so I thought that was really wonderful. I thought that in regards to Lindsay's opening, that it was really I thought it was really concrete. You were trying to build up the motive, and I recognize the motive in this case isn't perhaps, it is what it is. You've worked with what you had, and I thought that you did a really good job building that up. I could tell at the end you were getting rushed because the time was running out. And so I could really feel you pick up the pace there at the end. So I think, but I did think you had good pauses, and it seemed like you were speaking with intention on things, and that was really good. Then going towards the prosecution closing, I liked how you brought out what was it that you had to prove, and you brought out your elements, and you talked about that. And you were a little fast at times, but it wasn't too fast. I could certainly hear you all the way through. One thing to be, you're the prosecution, and you brought up, that, I have to prove this beyond a reasonable doubt, which is true. But then you're like, if there is any reasonable doubt, that you must acquit. And then you didn't say anything after that. And I was kind of like, well, let the defense, go there. And if you're going to say, well, you'd have to acquit if there wasn't beyond a reasonable doubt, you need to then say, and there is no reasonable doubt in this case. And just really, and make sure that you made that clear. It just kind of ended in a spot where it fell a little bit flat. And I thought in the close that maybe just bringing up the motive a little bit more, but I thought you covered everything you needed to cover, and your rebuttal was great. I think rebuttal is probably it's a really hard thing to do. You got to think on your feet and respond to what they said. And I thought you were just really concise and to the point, and I thought that was a strong way for you to end. As to the Defense, your opening, I liked your theme of the weakest link. I liked how in your opening you discussed what the witnesses were going to say. So we had a really good idea of what to anticipate moving through the case. And I liked in closing, the weakest link was brought back in. I really liked how you used words like they're reaching, there was a bias investigation. And one thing that I really liked about that was that your crosses really hit on that. And so it felt like I knew exactly what you were talking about because you had asked questions on that point. And so that was really good. Then you made one statement though, that I would just change a little bit of your words. You said, I hope we have proved that there is reasonable doubt. Remember, as a defense, you have no burden whatsoever. You don't have to prove anything. So just change it, that it's that they either they have not proved beyond a reasonable doubt, or there is reasonable doubt, but don't say that I hope we have proved, because it puts a burden on you that you don't have. I also thought you both could be a little bit, and it's hard over Zoom, and I know that, but to be, especially from the defense, to be just a little bit more righteous about this is the evidence that they're bringing, that they want my client to be convicted of murder, and this is what they have. I think it's okay to, show a little bit of righteousness or being upset on that point. In terms of the prosecution, the first witness, Alex, I thought your guys' objections and responses during that whole witness were fantastic. They were quick. You articulated it fast. There was no hesitation on responding. And this goes out throughout the entire trial. I don't think anybody abandoned the point they were getting to when they got objected to. And that is fabulous. That you all you knew. I think that there must have been some preparation in terms of anticipation of what evidence will be objected to and how I'm going to respond to this, which I think is one of the most difficult parts of trial preparation and one of the most important parts. And so I just applaud all of you attorneys for how well I thought that you were prepared to handle objections. And again, for all of the witness or all the attorneys doing directs, I thought you guys all had really good open-ended questions and had really good dialogues with your witnesses. It's hard when you're not in the courtroom. I always feel like one way I can always tell when a direct's going really well is when I'm just looking at the witness and I'm not looking at the attorney. And it's a little bit harder on Zoom to do that, but I did still nonetheless have that feeling like you were letting the witness have the stage, and that's how it should be on a direct. And on cross, the reverse, it's you really, you're the ones that are having that, those leading questions. And I thought that there was lots of really great leading questions on cross by everyone. One thing to think about though, when you are doing your crosses is that you really want to make sure that you're really only going after one fact per question. And I'm not even necessarily talking about compound questions where there was a few objections to those, but thinking about one fact per question and then looping, once you get your answer, looping in that new fact into your next question to build up a point that's really important to your case. Because it really will add to the emphasis of that if you just loop facts together to build on a point. So something for you to think about with that. I thought, let me see if there was anything else that was specific. Oh, Lindsay, on your cross, I thought you used fantastic transitions, which I really like. I knew where you were going. You're like, now I want to talk to you about this. And I just really liked that. It helped the flow of your cross and making your points. I have a lot of comments on objections. I was just really impressed with that by everyone. Let me see. I think that's really, I think like in general, like what I saw that I think was just fantastic overall. You guys just obviously put so much work and effort into this. You guys, honestly, your performance is better than some attorneys I've seen in the courtroom. So that's something to be really proud of. You obviously knew your case. Witnesses, you guys all did great. I know that that's a lot of hard work, learning all of that material as the witness and then being able to present it. And I felt like you were all really good, incredible. All of those who play law enforcement, just so you know, law enforcement, you can have a stronger personality and demonstrate some confidence, especially when you're an expert. You know, law enforcement certainly, you know, like they're in their answers, they're going to be strong in how they believe, and they're going to defend their investigation with confidence. So make sure, like when you're answering questions, don't be wishy-washy on it. One more thing, and then I'll pass it. That I really liked on your guys' crosses was when the witnesses would start to kind of run away a little bit, which is what witnesses do. I appreciated that none of you got in an argument with your witness because you're never going to win that argument. And so you don't want to do that. And instead, if you just didn't get a straight answer, which a lot of you didn't, you went back to it and you're like, so that's a yes. You were angry. Or, you know, and I thought that was an excellent way to handle that. It showed that you had control. And so I just applaud all of you. I thought that this was really fantastic and you were very well matched teams.
Thank you, Emily. Michelle, did you have anything to add? Susan?
Yes, and I think Michelle sent a note that she had to go. And
oh, okay.
I think everybody saw that in the chat. So I'm Susan Grauer. I've been a family law attorney for about 29 years. So I spent a lot of time in the courtroom, and I'm just going to echo what Emily and Judge Cachette said, and that is that your preparation showed. You all had a great mastery of the facts. I was particularly impressed, as Emily was, with how you handled the rules of evidence and objections. I frankly find that the most difficult part of trial because you can't always anticipate. And so the more you know the rules of evidence, the better off you're going to be. I just want to add, in terms of confidence, that as you get more experience with trial work, the thing that I love about practicing law, and especially in the courtroom, is that you get to be yourself. You get to be who you are. And if you roll in a mastery of the facts, the law, and the rules of evidence, you guys are going to be great trial lawyers. And I really enjoyed watching everybody and was very impressed. Very impressed. Thank you.
Okay, thank you. All right, Dawn, where are we now?
I think we're all completed. Thank you very much for your service. We appreciate it.
All right. Well, thank you, everybody. Great job and good luck. Hope everything works out for everyone.
Thank you.
And hopefully some of you go to law school.